Taco and Tech.
Man, I'm the king. Yeah, I'm the king. I'm the king of almost everything. I got it all. I got it all. All except for one fine thing. That thing is you and me. It's you and me. What does it mean to be the king? If you ain't got just what you need, a junkie star with no guitar. You got the papers but got no weed. I still want you, you don't want me. It's you and me. I may never see my fair queen lay next to me.
All right, welcome to another episode of Taco and Tech. What are we going to talk about today? We are tacoing with my man Marc Chavez from Marc Chavez Law Firm in Austin, correct?
Out of Central Texas.
Okay,
Originated
Central
from
Texas.
Austin, you know. Actually born and raised in Lubbock. I'm actually a Lubbock boy, native Lubbock High School, Texas Tech, Lubbock Christian, Tech Law, Tech Masters in Business. So, and then Lubbock DA's office. So, I'm a Lubbock boy, but centrally located.
Oh, well, there you go. There you go. Yeah, so we're going to talk to Mark here. We're going to talk about the Pop Isaacs situation and Title IX and what's involved and, why he's essentially probably not only should not be spinning, but, definitely should be playing right now. And then we have the court document that we'll go over. I'm not going to read the entire thing, but we're going to hit the main points and just kind of discuss, what's involved and hopefully clear up some bad information that's been passing on. So, but first, we'll give maybe some viewers some more time to get in if they're coming in late. But go ahead and just maybe talk about yourself and your credentials and your law firm and your practice. And I'll let you give a little commercial here for you. For anybody that may need some legal services in the future.
I appreciate your time. Marc Chavez Law Firm, we've been operating for 6 years. Prior to that, I was a prosecutor for 12 years. Started at the Lubbock DA's office, and if we back up a little further, I graduated from Tech Law and had a master's in business at Tech. Graduated in 2005. Lo and behold, I was the guy with an MBA that said I was never going to practice criminal law. And 18 years later, here I am, still practicing criminal law. But I was a prosecutor straight out of law school for the most part. Did 3 years at Tech and then had an opportunity to go to the state legislature to represent Matt Powell in the Lubbock DA's office at the time. Fell in love with Austin and then got a job at the DA's office there where I served for 9 more years as a prosecutor. Accomplished everything I wanted to do, so I decided it was time to chase my dreams and start my own law firm. Of course, when you're starting out your own law firm, there's that famous saying, have bar card, will travel. So you're really trying to pick up anything and everything, counties, different type of law, and you just have to learn it as you go. Well, one of the areas that I learned from the very get-go in 2018 was Title IX. And even still today, before this Pop Isaacs incident happened, when I would tell people I, specialize or do a lot of work in Title IX, a lot of people will say, what's that? I've got no clue what that is. Well, now it has been thrust, at least in the Lubbock community, in the Texas Tech community, it's been thrust into the foreground. But it's an area of law that I've been doing for 6 years, and it's a unique little niche that deserves the attention because of the type of allegations and the ramifications that it can have on the student that is alleged to have violated that student code of conduct. So I've been doing it for 6 years. I've been doing criminal law as a defense attorney as well as family and personal injury for 6 years. I thoroughly enjoy it. I still go back to Lubbock. I have family there. We're season ticket holders. So I still do work in Lubbock as well. So anytime you need a call, you give me a call. I'm sure he shared my Twitter handle or whatnot, markchavezlawfirm.com. We're here to serve you, and we take pride in the way we represent our clients. So I appreciate the time, Jeff.
Oh, absolutely. And yes, I've got your website, I've got your email. Where's my finger? In the description, so you can check it out. You go to his website, and his contact information is right there, front and center. So it's definitely easy to find. So, man, I appreciate you doing this. I guess we'll just get started with the Title IX, as you kind of just mentioned, and I don't want to go too in depth because I know there's been other podcasts that have covered it. But if maybe some viewers haven't listened to those podcasts, but just maybe I guess the basic process of Title IX. What we do know is that Grant McCaslin was approached about the Pop Isaac situation. He took it to I guess Kirby, and then Kirby took it to Title IX, or at least some process it got from coach to Kirby and Title IX in some deal. But I guess at that point, what do you know about the process?
So let's buckle up because I'm going to give you a very fast, educated version of Title IX. First, let's start right here. Do you remember the statement released by the university that said that Pop is in good standing and there is no reason to believe otherwise? Well, that is a statement based on Title IX. And where that comes from is Title IX is a university process. It's governed by federal law. And they're allowed to make up their own rules or on what they believe a violation of student code and conduct. So, for example, their definition of sexual assault, and I'll keep it to the type of allegations we're dealing with here today to keep it relevant. Their definition of sexual assault can be differentiated from the criminal law version, okay? But they govern their own students, if you will, or employees, because I've even had Title IX clients that were employees, okay? It's not just limited to students. But when a complaint gets filed, okay, and the allegations appear to mirror or fall into one of the allegations, in this case, sexual assault, then there has to be a mandatory process take place. Well, in 2020, about November, okay, there were so many lawsuits because the Title IX system seemed to be broken, and there was a bunch of lawsuits. Well, that just helped in the process. And what came of that was that there is a presumption added to the student who is being alleged of this violation. There is a presumption of being not responsible. And that's what you saw in that statement by the university, that he is in good standing, okay, because that's where they fall under good standing unless heard otherwise. Well, with that presumption of not being responsible, he's still in good standing. It doesn't matter what the allegations are. But onto the Title IX process, when it went to Grant McCaslin or even the AD, those people are what we call mandatory reporters. They have to report it to the Title IX office in the university. Under federal law, every university has to have a Title IX office where their main function is to investigate, follow the procedures, and ensure a fair hearing for both the complainant and respondent, and see what happens as far as the allegations goes to a final hearing. So what would happen in the Title IX process is, and it goes to an investigator initially, and the investigator's job is to gather relevant information. That includes interviewing the complainant, interviewing the respondent, any relevant witnesses that either party wants to throw in there to be interviewed, gathering text messages, emails, anything like that. That interviewer gathers all that information and they create a report. Then once that report is finalized, aka both sides had a chance to edit it or correct it, whatever, once it's finalized, then it gets set for a final hearing. Due to the type of allegations that there are here, it has to go to a final hearing. In that final hearing, it's pseudo court. It's not in front of an official judge. It's actually, Texas Tech actually uses a 4-person panel, but it goes in front of them, and we're allowed to call witnesses. We're allowed to cross-examine witnesses, whoever gets called, and question the evidence. And they have to prove beyond a preponderance of the evidence. That's that 50% plus a little bit more. They have to prove by preponderance of the evidence, of credible evidence, that the person being alleged to commit the violations is responsible. If they can't, and I answered this question on X to a good friend of mine, a lady that asked the question, if it's he said versus she said, how do you defend that? I'm like, well, that's it. If you argue it's he said versus she said, and they're both 50% credible, and you don't believe one or the other, then you argue that he's not responsible because they have to do that 50 plus 1, okay? But nonetheless, it has to go to a final hearing, and that panel makes a determination. There is a brief appeals process after that, okay? Now, federal law just says this. You have to wrap it up within a reasonable time. Some universities have hard and fast deadlines. I know one university has a 90-day deadline that they have. Others have 180 days. I'm telling you, I've been representing Title IX clients for 6 years. I don't believe one of my cases wrapped up within that deadline period. It just spills over because you're dealing with a bunch of evidence and a bunch of people's schedules. All it says is reasonable time. So when we're turning it back to what's going on here at Texas Tech, and people are like, why is he playing? Well, one, he's presumed not responsible right now. So he remains in good standing. And two, this process could take the better part of this entire semester. We don't know. So he's going to remain in good standing until that point. That's my understanding as to, or that's my best guess as to why he's still playing right now.
All right. And then, so do you have, a, or I guess what I'm trying to think of, do you have a time frame of, I guess maybe the entire process, and that's of course assuming, he's found whatever he's either found not responsible, or let's say he's found not responsible. I guess can the plaintiff appeal that? Let me start
Yes.
there. Okay.
Yes. Now, the appeals process in Title IX is limited to four avenues, and of course, you're gonna test my knowledge here. The four avenues aren't just I disagree with the ruling. I want somebody else to decide. It's not that simple. It's like new evidence has come to light that we didn't know of beforehand. It's that one of the hearing officers or all the hearing officers were biased in some form or fashion. And of course, I can't remember the other two off the top of my head, but they're very limited. Okay. And it goes to an appeals director or somebody to hear the appeal. And unfortunately, here's the tough part is that appeals officer decision is final. So let's say he gets found not responsible, the complainant appeals, and the hearing appellate officer reverses it. That's final. And that's unfortunate. But yes, there is an appeals process. And within that appeals process, they have like 10 days to make that appeal. And then the hearing officer has like another 10 days to make a decision based on the appeal reasons. Or actually, the respondent, for example, if Pop was found not responsible, he has an opportunity to respond to the type of appeal that they're making. And then it goes to the appellate officer, and they have 10 days to make their final decision. So you can see how 10 days, 10 days, and then it just gets stretched out.
Sure. Is it the same if he's found responsible and then Pop appeals? Is it the same or whatever? Okay.
Correct. Now, what would be very interesting is, for example, if Pop is found responsible, okay, and technically everything from probationary period on campus all the way up to expulsion is what he's looking at as a student at Texas Tech. What is the appropriate quote unquote punishment for him since we found him responsible? Okay. And then he says, hold on, I want to appeal, him and his attorney. So they sit down and look at the different avenues they can appeal. What's interesting is he does get levied a quote unquote punishment. Okay. So at that point, will the team or university suspend him based on that, despite his ability to appeal? I don't know. That would be their decision.
Okay. So, well, I guess explain the difference between, because this is a civil suit, not criminal. So I guess explain maybe some that don't quite know. I guess the difference between a civil and a criminal charge.
Okay. So, and I got asked this question on a different venue. And it's like, what's the worst thing that can happen with him in this civil suit? And the bottom line is the worst thing that can happen to him in the civil suit is him pay money to the plaintiff. Okay. He gets awarded, the plaintiff gets awarded a sum of cash based on, they found him guilty in the civil suit. Okay. And he has to pay some damages, and it's all based on, the young lady, she experienced emotional damage. They said physical damage. And then how far does that extract based on her, whatever she's doing to combat that damages, AKA she's seeking therapy, things of that sort. Okay. And then that's if it goes to a trial. Okay. There's also an avenue where they negotiate and they agree to pay a lump sum just to kind of get it out of the way. I don't want to take a risk at trial. You could get zero money. You could be penalized $1 million. We don't know. We'd rather hedge our bets and then see if we can't come to some kind of resolution. But it's all just paying money. His on paper, anything that happens in the civil suit cannot kick him out of school or get him out of good standing like Title IX can. All right. Take that to the criminal side. What's the worst thing that can happen on the criminal side? Well, everything. Criminal's the worst thing that can happen because he could face, on a sexual assault charge, he could face up to 20 years in prison, and he could face lifetime sexual offender registration. He would be labeled a pedophile for life. And he would have to be arrested. He would get a mugshot like we've all seen other people. He'd get fingerprints. He'd have to go through the whole criminal process. And, if it went to the criminal process, I would imagine, pure speculation, that the university would absolutely suspend him once the probable cause for the arrest came forward. So, I mean, that's the big difference. Civil is all about money. It's all about compensation based on what the plaintiff is alleging damages done to me by that person. So the worst thing that can happen is he pays money. Criminal and Title IX have much more bigger ramifications as far as your livelihood. Because, for example, if he's held responsible in Title IX, then he's going to be kicked out of or kicked out of school, most likely. Excuse me. But that follows him to every school in the transcript. Okay, it's part of his school transcript, so it follows him. Any job application they could see that, so it could have a lifelong ramification on which direction his life goes. That's the big difference. Civil is all about money.
Well, there's one thing I want to just clarify, because you said he may be labeled a pedophile if this come criminal charges, but since this happened in the Bahamas, is that it would be under Bahama law, correct? Is that, or can he be tried in the United States under United States law?
He cannot, because the actions that are being alleged happen abroad. Okay. And I've seen a lot of chatter about, well, Bahamas has an age of consent of 16 or something like that. And I've been trying to tell people it doesn't matter, because the type of allegations alleged, at least by this family, is intoxication, therefore the incapacity to consent, or by force, because she mentions tried to fight him off. And so it's like, it doesn't matter what the age of consent is. And the biggest question, which I don't know the answer to, is, did they ever go to the legal authorities, a detective, to file a criminal complaint? Or did they go straight to the courthouse to file a civil suit? I don't know that.
Right. Well, let's see. So I've kind of, I guess that's my questions for Title IX. At least that I can that I can remember.
How about this? I'll leave you with this, Jeff.
Go ahead.
They have a reasonable time to wrap up the whole process. Reasonably could be 4 or 5 months. All right. Yeah. While that's happening, based on the presumption of not responsible, he remains in good standing until that final hearing, if he's found responsible. That's my opinion as to why he's still on the team and why he's still playing.
Right, and which is a perfect segue, because that was my next point anyway. So not only and you kind of defended me on Twitter when I said this to one guy that he thought that Pop should be suspended, and I'm like, well, no, I don't think that he should, because if he's found, in this case, not responsible, I feel like Tech could be potentially liable. Is that correct? I mean, could there be a lawsuit from Pop to Tech if that occurred?
So let me kind of give a comparison to explain the difference. Okay, you see, there's kind of a similar situation going on in Illinois with T.J. Shannon. We all know T.J. Shannon. Okay, and Illinois suspended him. Okay, and everybody's like, well, why isn't Pop suspended? Here's the big difference. In Illinois, wrong, right, or otherwise, what they did was they went to the authorities, and there was probable cause that was found to make an arrest for sexual assault. Probable cause, okay, signed off by a judge. The judge says there's enough probable cause to go forward with a criminal allegation. That means a judge has looked at it, vetted it, signed off on it. Here, a civil lawsuit doesn't have that filtering. Any anybody can go to the courthouse and file a lawsuit. Now, obviously, they would be looking at frivolous lawsuit against them. But bottom line is, there's no vetting, there's no filtering of the legitimacy of these facts. You can go to the courthouse and file. And so that there's a distinction right there as to why TJ Shannon's suspended and Pop is still allowed to play because I said this before, a civil suit and the facts alleged are just mere allegations. That's it. And there's been no defense, no vetting, no filtering, or any of that. And therefore, let's say that they did. And this is kind of, I'm looking at what this TJ Shannon thing from afar and kind of observing what they're doing. Their attorneys filed a restraining order. And it's like, well, why would they do that? Here's the reason why, especially nowadays where these athletes get NIL, name, image, and likeness. If there's a company or TJ himself is losing out by not being on the court and having his name exposed out there, he could be like, hey, I'm losing out on money, and this company that's I've got a contract with, they're losing out because my name's not out there. And you guys suspended me without due process. That's and then you could see a countersuit where they're saying, hey, all this money I could have made with this NIL, you guys stopped it, you guys owe me. So you can kind of see that counter lawsuit kind of set itself up. I like what Texas Tech did here. Call me a homer. I am a Red Raider, but I do like what they did in just saying right now, and that statement by Tech was very well written. Kudos to whoever in the university making these professional statements. Is at this time he's in good standing, and that's why it reflects to me that they're following the Title IX procedures.
Yeah. Well, let's just go ahead and I definitely appreciate the information. We'll go ahead and switch screens here, and we'll just go over the actual document. And I'll just kind of, I'm not going to read the entire thing, of course. It's 9 pages, and some of it's just kind of procedural anyway. But maybe for those that haven't seen it, now you can. And I kind of mentioned this, when we first connected, but it's kind of the first time I've seen this. But it does say John Doe and Jane Doe, individually and as next friends of Janie Doe, a minor child. And so I kind of asked, well, what's a next friend? I'm just assuming that's a legal term.
It is. It's basically saying that the person who is harmed, the plaintiff, is a minor child, and they can't file a lawsuit on themselves. So, I mean, it's the legal way of saying the next person responsible who has the authority to bring suit on her behalf are these people.
Right. All right. So here they come, minor child, to file this original petition and request for jury trial, complaining of defendant Richard Isaacs for cause of action would respectfully show the court as follows. And so this first paragraph is just saying why they're being pseudonyms. John Doe, Jane Doe. We know it's the Steffi family, but for the sake of the what is this original petition? I think this is what it's called. Yes. They're asking for pseudonyms, and then they gave one to the friend, which is Amy. That's probably later. I think it's procedural. Here's where they are officially seeking monetary relief over $1 million. Damages are within the jurisdiction limits of the court, so we knew that. That's already been out there. So John Doe, excuse me, I've got my words, is the individual and father of the minor. Plaintiff Jane Doe is the mother. Plaintiff Janie Doe is the minor child. She's 17. Well, maybe Amy gets mentioned later, but there's a friend in the story. And then, of course, Richard Isaacs. Now, I believe he's a junior, but I guess that doesn't matter. Does that really matter? Could he get on a technical? Hey, I'm a junior. That's not me. That's my dad.
No, they really. I mean, no.
I'm sorry. I'm kidding. Also known as Pop Isaacs. Here, I blacked out his address, of course. Jurisdiction, okay, that's in Lubbock County. Here are the facts of the case. Now, I guess my next question, it does say facts, but some of these aren't actually facts. So I guess, is that just a term to say this is what I think?
You know, the fact. So you lay out the facts, okay? Of technically, it's almost storytelling, okay?
Yeah,
In a way, because if you see after facts, there's the next paragraph where it's actual allegations that they're alleging the sexual assault and then intentional infliction of emotional distress. But the
yeah,
facts, they still have to, stick to relevant terms that led us to the violations that they're alleging or the way that harm happened. And a lot of these facts are just, I was laughing when I was reading a couple of these. For example, right there, number 12, defendant Isaacs receives financial compensation for his name, image, and likeness. What in the world does that have to do with anything? I guess you could argue that it ties into the financial compensation and why they're asking for a million, but it has zero relevancy to the facts of what happened in the Bahamas and what happened ultimately in that hotel room. So things like that, it's like it's storytelling, but it's like that's not relevant. Absolutely
right.
not.
And then, of course, just to clarify, this is obviously from the perspective of the plaintiff, right? It's
Correct.
one side of the story. We don't, or at least we haven't yet heard the other
Yeah.
side yet, and maybe we never will.
99,
I don't know, but
I say about 98% of the facts, and it goes on for multiple numbers. They call them paragraphs, even though they're one sentence. Multiple paragraphs. 98% of this is based on my guess, educated guess, is interviewing of the father, and then the Janie, the minor daughter, and that's where these facts allege. And then I say 98% because there's a couple paragraphs in there from player Cambridge, as far as what he told the father afterwards. And actually, I think that's very
right,
intriguing of what Cambridge told the father, that everybody was drunk. And it was like, well, that poses an interesting situation, because who is to say that he consented to anything if he's intoxicated as well? But that's just my picking out brain of seeing where you could attack this. And I'm not sitting here telling you that I'm, pro pop because I don't want to, I I'm not doing that. I'm just saying, where do these facts come in as relevant? And a lot of these facts storytelling is just fluff and it's not relevant to the cause of action, in my opinion.
right, yeah, and I agree, of course. But yeah, the first one, he's a student athlete at Texas Tech. Confirmed. That is a fact. He does receive financial compensation. He's received that from me because I do, or have sold Pop Isaac's autographed basketballs. So full disclosure there. If you weren't aware, I've done that. Still have some. And so November 2023, the Texas Tech University traveled to Padre Island, Bahamas. We know that this is where it happened, in the Battle for Atlantis
See,
college basketball tournament.
and all those factual stuff, relevant, completely relevant. I'm not sitting here saying that all these paragraphs are ridiculous. No, there's just a lot of stuff in there that is like, what does that have to do with anything? Because he kind of lays out how they got there, how they got up to the room, how they got separated. And I say they, I'm referring to the Janie minor daughter and the defendant, Mr. Isaac. A lot of the facts allege how they got where they were. Okay, got it, relevant. And I hate
Yes.
to jump the gun, Jeff. I know you're going slowly one by one, but
No, you're
part
good.
one part that got me at the very end is he being the attorney, I guess, writing this, starts talking about the university not having supervision, the university not watching curfew, and I'm like, y'all trying to go after the university too? Is that what y'all are doing here? So
Yes, that is definitely one of my questions when we get there, and I think we're getting close. But
like I said, I'm sorry to jump the gun.
no, no, you're fine. It definitely shows the viewers that you've read it, of course. But here's where Amy comes in. Mr. and Mrs. Doe took Janie and her friend Amy. Of course, that's a pseudonym. That's not her real name. She's 16, a friend of the daughter, as well, and they stayed in the same resort. The basketball tournament concluded on the 24th, Friday, or 24th. So this is after the tournament's over. I'm sure the coaches were like, "Hey, you had a good tournament, and enjoy your time. While we're here." I'm not sure if they came back on the Saturday or if they stayed. I'm not sure the time frame on that, but so this is after everything's over, and this
Jeff, I'm
is.
walking around with you just so I can get a charger going on.
Oh, you're good. And then Amy starts talking to Devin Cambridge. So they, add. There's no charges against Devin Cambridge. They're just including him in the storytelling. I suppose because he's the one that maybe invited them to the room later on. But so we'll just say the family was in the casino area along with the team. But we actually do have photo evidence of that. We may have to see if he. Okay, I can hear you.
Yeah, I'm still here.
I lost video, but I can hear you.
I'm still here.
Yeah, you're good. And then defendant Isaacs and Cambridge and a known supporter of the team, which we're going to call Booster, were playing blackjack. And then, so about this time, or roughly after Cambridge and Amy began to communicate via text, and they continued to socialize. So Mr. Doe, or Matt Steffi, walked by the blackjack table and saw Cambridge, saw Isaacs and the Booster playing. This is where we're getting a lot of the irrelevant stuff that you mentioned.
Exactly.
I don't know if they're, is this a potential attempt to get NC involved with Texas Tech because a Booster provided, according to this, drinks and gambling chips?
Well, and I definitely don't want to go rogue on NIL and how it's regulated or not regulated. I'm not going to go there. But, you see he's adding the boosters in there, and you see he's talking about the university. And my speculation is, are they going to try to get insurance policy money from the university for lack of supervision if found responsible? Don't know. But, if I'm defending this in a civil defense, which I don't do, by the way, I would, toss out the petition for false statements, things that aren't relevant, stuff like that. But like I said, I don't do that. That's pure speculation on my part. It would be fun to defend this because I see a lot of facts in there that I'm like, really, I would love to depose certain people about that night. That would be fun. But back to what you were talking about, a lot of those statements just aren't relevant. It is storytelling, but it has nothing to do with the cause of action.
Correct. Yeah, generally. Now here where we, and this I find interesting, Mr. Doe observed Booster repeatedly buying, drinks for Isaacs and Cambridge, probably some other players, but these are the only two players named. And then 26, after having several alcoholic drinks, Janie became intoxicated. I feel like it leaves out maybe how she got those drinks. And with, I don't want to address rumors, but we have some eyewitnesses that know that. And it says that around midnight, now I found this interesting, so I want to ask you about this. Mr. Doe said to Booster, "Man, Papa's killing it." And Booster replied, "Well, yeah, I staked him, taught him, and got all of us drunk."
You know what I find real interesting, Jeff? I'm starting to step out there and just give my opinion on stuff. And you know what? Disagree with it, go ahead. I don't care. But it's very interesting in this petition, because I'm pulling it up with you so we can go along together. It's very interesting that in these allegations and these facts, it just so happens that all these people are saying all these incriminating things. And Mr. John Doe just hears this amazing incriminating statement. Well, yeah, I staked him, I taught him, got us all drunk. I mean, come on. You're still adults dealing with children, okay? And you're sitting there admitting to another father you got everybody drunk. It just makes no sense to me. Just like later on, once again, I'm sorry, Jeff, you're going line by line, but it's in context of what we're talking about. When the conversation that Janie overheard Cambridge and Isaac's talking about in the elevator about I don't want to catch a case, and Pops just says, "Oh man, why didn't I think of that?" Really? Like he's just going to make an incriminating statement just like that. Okay, all right. And then the other one just says, a drunk booster gave them all money and bought them all drinks. It was like, okay, you must have the
Yeah.
most perfect evidence to have such incriminating evidence. I mean, the comments were just cop perfect. Um, and Pop says, "Man, why didn't I think of that?" Really? Do you really think he said that right after that? Anyways, those
Yeah,
are my thoughts.
and I've got a comment on that. When we get there. But so my question here is now, because I watched the Johnny Depp case, so I'm a professional litigator now. But I spent 8 hours a day, not 8 hours a day, but anyway, I had it on at work. I thought it was fascinating, but there was a lot of objections to hearsay. So
Mhm.
is that what is this hearsay? Is this we've got a direct quote. There's no way that can be verified, can it?
I can tell you this, Jeff. If you're listeners and you have about 10 hours, I can tell you what hearsay is. If you
Okay.
got time, get comfortable, get a midnight snack. Listen, hearsay is an out of court statement. Okay. In other words, let's take these individuals. Let's just take it into context here. And Mr. Doe is testifying in court, and he says, "Well, I heard Cambridge say," and the minute he's trying to say what somebody else says, boom, there's hearsay. Now, there are some exceptions, okay? There are some exceptions, and the reason why hearsay is not allowed is because we want to verify the truth of that statement, make sure it's credible. So, the only way we can really ensure it's credible statement is to have that person themselves come and make the statement in court rather than Mr. Doe relaying what he heard somebody else said. Let's bring that somebody else into court to say it. Okay, it ensures the validity of the statement. Now there are all kinds of exceptions to hearsay. For example, Mr. Doe or you know Janie, minor witness, can say, "Pop Isaac said this," and you would normally jump up and say, "Well, that's hearsay because she's saying what somebody else said." If it's a party opponent, in other words, the opponent in the party that we're dealing with, if it's their statement, then it can come in. It's not hearsay because that person, the opponent in this party, has the right to testify on the stand and verify that it's true or false. Same thing with Pop. Pop's allowed to say, "Well, Janie said X, Y, and Z." Janie's attorney's not allowed to stand up and say that's hearsay. No, because it's a party opponent. She's allowed to take the stand and verify whether that was true or not. So that's like one exception. But basically, if we're going to get these statements in from these people, especially like this Cambridge statement and audio recording, supposedly, they're going to have to bring Cambridge in and depose him, or he's got to testify to that statement for it to come in.
All right. Okay. So just to get back, we are about to approach 1 a.m. To the next line. We do know that after having several alcoholic drinks, Janie has become intoxicated.
Hmm.
And then Cambridge sent Amy, which is the friend, pseudonym, not her real name, a text message inviting the two girls, Amy and then the daughter, up to his room.
Hmm.
So Janie went with Amy to the elevator to take the elevator to go to Cambridge's hotel room. I'm trying to read kind of fast.
Hmm.
When they arrived, they could not remember his room number. Cambridge came out of his room to the hallway and said, "I'm in here." Which, I mean, I feel like they could just text, "Hey, where you at? What room number?" I feel like if you're inviting them to your room, my room is anyway. And again, irrelevant.
Hmm.
What is relevant is that we know that they were in the room together. I mean, that hasn't been disputed as far as I'm aware. So they went in and they were shocked to see defendant Isaacs in the room too. So I don't know if that's a verifiable emotion or I don't know. But that's and she could have said that, of course, in the interview.
In fact, go ahead. I'll make a comment after you read a couple of lines because
Okay.
there's something that comes to mind that is extremely shocking to me.
All right. After sitting on the bed for a few minutes, defendant Isaacs took a random picture of the floor on his Snapchat and typed out a message on his phone telling her to go to his room and let Amy and Cambridge chill alone, and showed message on his phone to Janie. So I guess we have a Snapchat, possibly.
Well, it doesn't
Proof.
necessarily say he sent it. The way I read that is he prepared a message, typed it out, and then showed her on his phone, but didn't send it to her. So I don't know.
Oh, okay, that's true. So that could be something that couldn't be even verified, potentially.
Correct. Correct.
Defendant Isaacs took Janie to his hotel room. Janie remained intoxicated. All right, so once inside the defendant's Isaac's hotel room, he began having sexual intercourse with Janie. Janie does not recall how her panties were removed. Janie did not consent to having sexual intercourse with defendant Isaacs. Janie did not ask to have sexual intercourse. Janie did not agree to have sexual intercourse. So here's the I guess meat and potatoes of the actual complaint. Janie did not comply with defendant Isaacs. This is an odd sentence. Have sexual intercourse with her, and attempted to fight him off. So that's key on their side to show, there was no consent. Now, at some point, while Janie was in defendant Isaac's hotel room, another Texas Tech University men's basketball teammate briefly walked in the room momentarily. I feel like that's redundant. Briefly, momentarily walked in. Yeah. Defendant Isaac then got a phone call from Cambridge to head downstairs. Janie got dressed and went with defendant Isaacs and met Cambridge in the elevator to go downstairs. So this is what you were referring to, and this is kind of what I have a point as well. In the elevator, Janie asked Cambridge where her friend Amy was, and Cambridge said, "She'll be out in 10 minutes. I don't want to catch a case." And then I don't even know what that means, but I guess you think that means like a rape case? Is that what?
I have
A criminal case?
No, I'll be honest with you. I have no clue what in the world he's referring to.
I
I
don't
mean,
either.
I can only guess that I don't want to catch a case. Yeah, criminal case. Yeah, that's what I would guess. But what I'm trying to figure out is how would Cambridge catch a case with Amy? I mean, are they trying to say that he's confessing to potentially doing something and he just didn't want to get caught? Like, I don't know. That one, I read that about 5 times and I'm like, what in the world? But once again, here's Janie catching all these just magnificent confessions from these people. And it's like, I don't want to catch a case. And defendant Isaacs responds, man, why didn't I think of that? It's like, okay. Once again, and we talked about it at the beginning, Jeff, these are all one-sided alleged facts by the petitioner,
Correct.
based on the interview with the minor daughter Janie and the father. Okay, so it would what will come to light. Now, the defense has these options. Okay, they can file a general denial, and literally it can be one line that says we generally deny all the alleged facts. Okay, boom, done. And then they go into civil discovery, depositions, probably subpoenas for text messages, anything if there were messaging back and forth, something like that. Okay, or they could have a complex denial and actually have his statement of what he says happened in that. Probably not wise to do that because you want to hold that for your defense, not put it out there right front and center right away. But we have yet to hear anywhere close to frankly, obviously, I would love to see what Cambridge says, and when they meet with him and talk with him, um, as well as Isaac's and his side.
Yeah, but what I find interesting, and please know, I have no intention of, I don't want to victim blame here. That's not my intention. But I just find it curious that she's intoxicated, doesn't remember, or to say doesn't remember when the panties came off, or whatever the line was, but then she remembers an exact quote.
Yeah, and that's what the shocking thing that I said earlier. And I'm looking at this as just from a, does it pass the eye test when I read it for the first time, or are there holes that need to be shored up or that you can pick apart? And that is exactly what you just mentioned, Jeff. And that is, there was a bunch of vagueness in the room. I don't recall how this happened, but she's very specific on how they got there. She's very specific on afterwards where they went, and very specific on the quotes that she heard. And it's like, okay, yet in the room it was so hazy that you don't remember anything. that that is what came out big time. And I imagine whoever's Pop's defense team is, I say, have a heyday. They're going to pinpoint that and nitpick what happened in that room. And I don't mean minute by minute. I mean every 10 seconds by 10 seconds.
Yeah,
Just pick apart it, because it's like, okay, you walked in the room. What do you remember doing first? I don't remember. I don't remember. I just don't remember my panties coming off. Okay, so, but yet you remember walking into the elevator, and you remember seeing Cambridge there, and you remember seeing what he said, and then you remember Amy. You see what I'm saying?
yeah,
And then just going after it. And that's, if I'm looking at it from the plaintiff standpoint, it's like you better start shoring that up. And if you're looking at it from the defendant standpoint, it's like that's where you start attacking, because obviously what happened in that room is the crux of everything, and that's where we need more detail.
yeah. And then also, let me just throw this point in there. You have five people see a car wreck. You're going to get five different explanations as to what happened based upon their perspective and what they saw and things. So I guess I just because I've been asked about getting hit. I'm just throwing a bone out to the plaintiff here, and maybe not remembering every little detail,
Sure, sure, absolutely.
and explain, and I've had, where I've misremembered a few details on, getting hit and, the engine adjuster. And he's like, oh, wait, what really happened? And then I'm like, well, okay, you were right. I was wrong. It happens. But because I
And,
do not want to
and one thing that needs to be,
victim blame.
I say scrutinized, Jeff, not examined. How about that? One thing that
Yeah.
needs to be examined is, she's alleging, let's be honest, let's talk real. She's alleging rape by force and with lack of consent based on intoxication. And so a lot of the examination is going to be, okay, you were basically taken beyond your will. Got it. When's the first time you reported it? When's the first time you thought about getting checked out? Is there any examination? Because there are sexual assault examinations. Did you go through that? And it's like, how did this come about to come forward to a petition? You heard that basically he was bragging about it. And it's like, so the motive for coming forward, and because the examination of her as a victim will be, okay, understand it. And there are no one victims. And like I said, I was a prosecutor for 12 years. Okay, there's a fight or flight. Not every victim's going to kick and scream. And the minute that he leaves the room, or the minute you separate, you call 911. That doesn't happen with every single one of them. I get that. But it's going to be examined as to why you never went to get checked out, with medical personnel. Why you never called the police? Why didn't you run to your parents that night and say something terrible happened to me? Not even authorities. The time lapse is going to be scrutinized, wrong, right, or otherwise. Okay. Once again, I'm
Yeah.
not taking positions here, but it will be scrutinized as to why that wasn't done.
Yeah. And then and just to kind of side with the plaintiff on that. Is you just never know how you're going to react, right? When there's trauma or traumatized or or whatever. So it's wise not to just judge immediately on things of that nature as to why didn't you immediately. I mean, we've had countless reports of they felt embarrassed or ashamed, whatever. Because I mean, it's a very serious
Exactly.
charge or an event
Exactly.
in their lives. So I definitely want to point that out here and try to be as fair as possible, but also pointing out like we are some at least potential. We'll call them holes, like you said. We'll call them holes in the story.
Yeah. Yeah. And I want to make it clear to everybody that I'm not citing here. I'm just examining it for what I would think is deficiencies to shore up for the plaintiff. If you're going to make a solid case, you need to shore up these areas. And for the
Yes.
defense side, these are areas to poke holes in because there's a lot of holes to poke in this. If you're serious, and once again, let's talk about it. He's asking for $1 million. It's like that's not well. For some people, it may not be that may be chump change, but for the rest of us, that's a lot of money. We're not talking about a little lawsuit here.
Right.
Um,
And Pop Isaac does not have $1 million. So anyway, we will. Okay, the next part of the story. Janie went downstairs or waited downstairs for Amy, and Janie called Amy to ask where she was. Amy said she would be down soon. Once they were reunited, they went to their room to sleep. On the morning of Saturday, November 25th, Mr. Doe sees defendant Isaacs and Cambridge in the lazy river. Mr. Doe, Matt Steffi, heard defendant Isaacs and Cambridge make comments saying a drunk booster gave them all the money and bought all of the drinks. So, and then you kind of mentioned this. At no point in time did there appear to be any sort of curfew in place for Texas Tech men's basketball players to be in their hotel rooms at a specified time. At no point in time did there appear to be any sort of supervision of Texas Tech University basketball players in the casino. At no point in time did there appear to be any sort of monitoring of the Texas Tech basketball players' hotel rooms to ensure underage girls were not going in or out of the rooms. And I guess that's just there to make it relevant to this particular case. I guess my question on that is that the university's responsibility? Like, why would they even implicate? Texas Tech is not part of this lawsuit, so why are they trying to implicate Texas Tech? I guess is my question. Not that you can answer that, but that's I'm wondering.
That's what I'm wondering is those statements. I'm just like, what in the world is? Same thing. There's another one later on about him being Big 12 Player of the Week. What in the world does that have to do with anything of what happened in the Bahamas? That's just ridiculous. The Texas Tech statement, and frankly, it's been many years, Jeff. I played college sports many years ago. And the sad part is, I can't even remember if we had curfews. Obviously the coaches were like, don't be out all night long, don't be stupid. But I can't even remember if we had curfews. That's how long ago it was. But they're being mentioned in this lawsuit is just, that's not cool. Especially if you're not going to name them as a contributor or a factor to all this. That was inappropriate in my opinion.
Yeah. And then conveniently, right? The plaintiff, or I guess I'm calling her the plaintiff, and I guess it's really maybe the whole the family. But mom and dad was there, so why are they not the ones in the supervisory role?
It's very interesting. Once again, Jeff, I don't really do civil law. I do car accident cases, and they're few and far between. But I would be interested from a civil defense attorney standpoint of what contributory negligence the father would have on negligence. Is there a negligent supervision, contributory negligence? I know there have been allegations that the father was helping contribute to alcohol of the minors. I don't know if that's true. Don't know if that's true. But he also mentions, or at least it's mentioned in here, that she was drunk and he was around the kids the whole time. So that was very intriguing to me as far as that aspect. it's a little bit interesting that the suit is brought on by the parents, and they were all up in there as potential fact witnesses themselves to what happened. Does that make sense? I'm not saying they're
Yes.
responsible. I'm not saying it's their fault. I'm saying that they could be key witnesses to what led up to going to the hotel room. And so that's oof, a little conflict of interest, possibly. I don't know. But that would be an interesting angle to look at.
Yeah, I'm not sure the legal responsibility, but I feel like as a parent, I would be, watching
Yeah.
my kids. Over the next few weeks, Janie told no one of the sexual assault. That's common. Defendant Isaacs told other Texas Tech University basketball players that he had sexual intercourse with Janie. Defendant Isaacs told other Texas Tech University female student athletes that he had sexual intercourse with Janie. On December 13th, news traveled to Janie that defendant Isaac was bragging about having sexual intercourse with her. Janie was devastated. Understandable. It is. I guess let me just clarify the bragging. Is it? I guess in a legal sense, is bragging just mentioning somebody? Is it actually? And I don't know. I guess I don't know what bragging would
Yeah,
would be.
sure.
Kind of happy. Hey, look what I did. Type deal. I
And
don't know
I'll be honest with
what's
you,
the.
yeah. Because we both were young, dumb 19, 20-year olds. I know I was a young, dumb, cocky athlete, 20-year old. So we do stupid things. I will be completely honest with you and say, reading this, Pop is guilty of being a young and dumb dude. Does that equate to being responsible? I don't know. That's not for me to say. Okay. So the bragging part about it, what's interesting about this is it mentions no pain felt from the victim prior to hearing about the bragging. Because later on they ask for physical pain felt, but there's no mention of doctor's visits or aftercare or anything of that sort. And then the emotional distress came from the combination of the sexual assault, but also I guess, the embarrassment, you could say, of learning that somebody's bragging about having sex with you. And that's a dumb move on Pop's part. Even if, I mean, frankly, even if you're just talking about it, you know, to answer your question, like, what is bragging? Was he out there? Bragging can be so many things, in other
Yes.
words. All right. And so, yeah, that can be quite the embarrassment for the plaintiff. Absolutely. No doubt about that. And frankly, that was just a bad move on his part. Very ill advised. And I imagine his attorneys are probably saying that. Dude, you should have just kept your mouth shut. Frankly, just keep your mouth shut. Because it seems to me, after reading this, that a lot of this lawsuit stemmed from the bragging, and it got word out in the sports community. And frankly, it's an embarrassment to the whole family. We all know that the brother of Janie was on the team. We all know that the father was a very close. I don't even know if he's booster. I don't want to categorize him as anything, but I know he was close with the team. So it can cause a sense of embarrassment for Janie and the entire family by you spreading out the knowledge or bragging that you did this.
Correct. Yeah, and I didn't mean to harp on bragging. I just thought it was interesting, just to try to define it,
Right.
because it can mean
In,
different things. And
in
and
other
then,
words,
and then to the
there's
plaintiff,
no.
even just mentioning it could feel like bragging. So I don't want to.
Right.
I'm not trying to necessarily disparage her
Right.
specifically. I was just curious on if there's I guess, a legal definition, kind of
No.
the way I put it. But so later that night on the 13th, so this is the day when she found out that Isaacs had told some others, apparently male and female. Jane disclosed to her parents that she was raped by defendant Isaacs while in the Bahamas. So I guess, to your point, maybe this is the first time that she's told somebody. But it still doesn't mention, as you said, any kind of medical care.
Yeah.
And you would think that they would include that
Yeah.
if it happened, because that would be included in the charges. And I don't think there's any medical mentioned. Early December 14th, this is when Matt Steffi contacted Texas Tech basketball coach Grant McCassin and informed him that Janie was sexually assaulted by defendant Isaacs. On information and belief, then the coach reported the situation to director athletic director Kirby Holcutt and other Texas Tech officials. And of course, that's when we know that Title IX got involved. Now, on December 14th, Cambridge sent Mr. Doe a voice recording which said, "At Nobu," is that the name of the hotel, or maybe that's the place they were at, or the casino? I'm not sure. I haven't looked that up, but this is the real deal story right here. At Nobu, we was all at Nobu. You remember drinking, everybody drinking and stuff, so everybody's drunk. Cambridge goes on to affirm that Janie and Amy were in his hotel room with defendant Isaacs. Cambridge said that defendant Isaacs and Janie left the room so he could be alone with Amy. Cambridge then says everybody was just drunk and we all went back downstairs. Which I guess that's maybe Cambridge's way of denial. Maybe that nothing happened at that kind of.
He's using that statement to support his claim that Jamie was intoxicated and could not consent. Okay?
Right.
But he also doesn't. I guess I don't know. I would love to sit down and pick the brain of this attorney and why he included some of these stuff, because it's he's using that statement by Cambridge, obviously gotten from the father from a voicemail, that everybody was drunk and we all went downstairs. Okay, so now if everybody's drunk, now we thoroughly can start attacking the credibility of everybody's story, because it's like, how much do you remember if you were that drunk? And now it's a free-for-all for all litigators to start deposing and nitpicking every single little thing. Because he believes that Cambridge statement helps him because it supports the cause that Jamie was intoxicated. Yes. But it's like everybody's drunk. And if Jamie was so intoxicated, she remembers a lot of certain details, and I say convenient. For the defense standpoint, it's convenient that in the room she doesn't remember anything. But she remembers before the room and after the room. So.
Right. Yeah. And also, potentially, you remember drinking, so and this is too, Matt Steffi. So Matt Steffi was probably drinking as well, right? Maybe that's why, maybe he went to the hotel room, went to sleep, possibly. I'm not like alleging anything. I'm just saying, I guess to say why he wasn't, supervising his daughter from my previous statement, I guess is what I'm saying. All right, so Cambridge admits that Janie was intoxicated, another confirmation. Cambridge confirms defendant Isaacs took Janie to his hotel room. Since Mr. Doe reported the sexual assault to Texas Tech, defendant Isaacs has started every men's basketball game, and he continues to be an active member of the Texas Tech basketball team. You kind of mentioned this. On January 2nd, Isaacs was named Big 12 Player of the Week, and Texas Tech promoted and celebrated his achievement, as they should, right? That's a big deal. His first one.
Mm-hmm. Yeah.
So I guess they're alleging maybe he should be suspended. I don't know why that's even in there. Like kind of like you said, it's irrelevant to anything. He doesn't get money. He didn't get $1 million from doing that. So.
Like, I guess the stretch is so far that you might pull a hamstring, but they may be stretching that by celebrating and promoting him, that even though they know of these allegations, it further deepened the emotional pain Jamie felt. But they don't make that connection. And, I mean, that's still a very, very far stretch, that him being Big 12 Player of the Week is what helped contribute to her emotional distress. Is like, make that connection, please. But it's not alleged here in that connection.
Right.
So without that connection, it's like that statement just has no place in this. Like, it's irrelevant and worthless.
Yeah, and then court here, as a result of the sexual assault, Janie was injured, felt pain, and has suffered mental anguish. So this is their ultimate claim for the $1 million, essentially. As a result of defendant Isaac's bragging to other student athletes about having sexual intercourse with Janie, and Janie learning of what defendant Isaac has said, she has suffered severe emotional distress. So this is kind of a tack on.
Yeah. When you get that count one sexual assault, you're always going to see that count two of emotional distress.
Yes, yes. Okay. Okay, 60, defendant Isaac's. So I guess this is the official claim. But anyway, defendant Isaac's intentionally, knowingly, and recklessly engaged in unconsented physical, offensive, and sexual contact with plaintiff Janie Doe. Defendant Isaacs engaged in sexual conduct with plaintiff Janie Doe when she did not and could not have provided informed consent due to an intoxicated state. Defendant Isaacs. Okay, Isaacs had sex with her. It just goes into.
Now you're starting to get into legalese. Yeah.
Yes, so he penetrated. Defendant Isaacs caused bodily injury and damages to plaintiff Janie Doe. Intoxication of defendant Isaacs is not a defense. So that's my question. I guess, is that true? Number one, is that are they just claiming that, or is that a true legal standard that the intoxication of defendant is not a defense?
It is not a defense. Intoxication is never a defense. Okay. Now, and this is where we have these arguments in law that non-lawyers would think we're so dull, and my wife would say that y'all are so boring and nerdy. When you say intoxication cannot be used as a defense, you can't get up there and say he's not liable because he was intoxicated as well. Therefore, he could not intentionally or knowingly, right? You cannot outwardly say it's a defense. But in the back of your mind, you're going to be like, everybody's drinking. There's no way he intentionally did this without her consent because everybody's drunk, and you kind of just throw it out there knowing intoxication is not a defense. But you can also use, and notice it says intoxication of the defendant, because intoxication of everybody can absolutely be used to attack their credibility and what their memory was like and what they remember. Okay? It can be used in both ways, and I'm just spotlighting on the statements made in the facts, because once again, we only have one side. If we had in that general denial that I mentioned earlier, if it was more specific and we saw Pop's side, I'd be sitting here ridiculing and poking holes in Pop's statement as well. But we only have one side, so I can only pick at what they're saying, and that is this: she is very specific about how they got up to the hotel room. She's very specific about what she heard and what they did afterwards, and it's very open, broad, or cloudy, if you will, because she was so drunk in the room. And the intoxication can be used to attack her credibility, and therefore she's not credible, and you cannot believe these allegations. So you can use intoxication left and right to attack the case and win the case based on intoxication.
Right.
You can't outwardly say he was intoxicated, therefore he did not know what he was doing, he should not be held liable. That is absolutely true. It cannot be a defense.
All right. And the exemplary damages: plaintiff's injury resulted from defendant Isaac's actual and intentional fraud, gross negligence, or malice, which entitles plaintiff to exemplary damages under, whatever. Okay, that just seems. Defendant Isaacs knew or should have known the risk associated with his behavior and nonetheless engaged in the unconsented conduct. Let me see if there's anything. I guess we're here. So plaintiff Joe, emotional distress. I guess it's just kind of outlining, or this is count two. I guess I should read intentional emotional distress. So I guess this is confirming the emotional distress portion, and this is the actual sexual assault. Okay.
No, this is basically his intentional acts caused. So the first one is just sexual assault. He intentionally, knowingly, uh, you know, penetrated me without my consent. Okay,
Right.
this one is based on him intentionally, knowingly penetrating me without my consent. He caused me emotional damage based on his intentional acts.
Yes. Yeah. Intentionally, knowingly, and recklessly inflicting sexual assault and or bodily injury, and then by telling other people he had sexual. So here they just have telling before they had bragging. I
You know,
don't
it's
know.
interesting in that, of course, it says and or bodily injury. At no point in the facts above does she allege that she was hurt. Now, let me stop there. I understand sexual intercourse beyond somebody's will, but they never actually spell it out in the facts or the
Yes.
allegations, and they could actually move to exclude that statement. But it does say sexual assault and or bodily injury. I just thought it was I caught that they never actually allege bodily injury in there.
Right. Yeah. And I think this is the first time we really see it.
Yeah.
If I remember, I won't go back fully, but count to Isaac's was intentional and or reckless, extreme and outrageous. Um, Defendant Isaac's wrongful conduct proximately caused. So is what's the use of approximately? Is that
Proximate
what?
cause means there's a connection between
Okay.
his
Okay.
wrongful conduct and her emotional distress.
Okay. Uh, s- to play it, causing the damages outlined below. Okay. So here are the damages.
In other words, they're saying the emotional distress is not caused by being a 17-year-old teenager in high school. It's because of the direct actions of what he did.
Right. Yeah. Yeah. Proximity. Um, okay. Isaac knew or should have known as a proximate cause of the occurrence of question. Here we go. Jane Dillon suffered serious and permanent personal injuries and is continuing to undergo treatment for such injuries. Um, so I guess this is the first time we see actual treatment being mentioned.
Yep. Yep.
Physical pain and suffering in the past, physical pain and suffering in the future, physical impairment in the past, physical impairment in the future. Now, I guess in that sense, they're just asking you to take the future into consideration if you're going to award damages, right? There's not like if she has additional medical bills, so to speak, he's not responsible as well, or is he?
He,
If
he
he's
can be.
found.
He can be. For
Okay.
example, let's take medical. There's a couple of different avenues. There could be medical bills where she's once again, I don't want to speculate, but if she's seeking medical treatment and there's a plan where you got to come back for 3 follow-ups, they're asking for coverage of the future follow-ups based on the doctor's plan. As far as therapy goes, she's seeing a therapist because this is traumatic, and I've now got to deal with potentially being diagnosed with PTSD. Therapy can last for a while. It can last on and on and on. And so they're asking for any future damage. Now, what's going to happen is, and this is the way that these civil cases happen, you wonder why they can get up to even thinking about $1 million. Well, they go hire an expert, and an expert is there to forecast the necessary medical and therapeutical, I don't know if that's a word, therapeutic uh, forecasting as to what would be needed to treat what has happened to her if it's found responsible or he's found guilty for doing this. And then it comes up to an X value of future damage. And so that's why you see all this suffering in the future, physical impairment in the future. Now, the physical impairment is interesting because you're saying there's going to be physical injuries in the future. Obviously there's got to be that proximity that we talked about, that proximate cause of
Right.
how future physical impairment was caused by this. Um, but the reasonable and necessary medical expenses, that sounds right. And when it says in the past, obviously it's referring to from the time this alleged offense occurred at the hotel
Right.
room. That's in the past from the time they filed it, going to the future.
Right. Yeah. And then of course, yeah, reasonable and necessary medical expenses, past, future, mental anguish in the past and future, and then exemplary damages. And then
Correct. And
somebody had asked me about this, but plaintiffs hereby demands a trial by jury.
you have to allege that at the beginning.
Yeah.
Not everybody goes to a trial by jury, but you have to allege that in the beginning. Um, it ties into those procedural stuff that we looked at the very top
Right.
with the amount of damages they're asking for. That statement right there is the same thing. It's all procedural. You got to ask for it now.
All right. And I guess that I guess he paid a fee to request that. So I don't know.
Honestly, it's a real cheap fee. It's not an expensive fee at all, but it's a cheap fee. But bottom line, okay, we just spent a lot of time talking about the civil action, and talking about the facts and why certain things are said in there and what certain things mean. The bottom line is this, for all the Texas Tech fans out there: this whole petition, as it plays out, will still have no effect as to his playing or his standing with the university. Okay, this is literally him as an individual and what he's responsible for or not, if he's going to be found not guilty, or does he just want to say, hey, can we come to a settlement? And however he handles that, of course, he's an individual, right? Typically when we see $1 million lawsuits like this, I'm just going to move it over into a trucking accident. It's an 18-wheeler with a truck company that's got multi-million-dollar policies. That's where you see those types of sums, and it's serious bodily injury. This person has a broken leg or an amputated arm, and their life is affected forever. And so those future damages you can see of how they're affected. And that's how you get into these $1 million ranges. Right here, it's literally a father and mother suing a college kid. And maybe that's why they put up there that NIL to see, but it's still just him. Now, there are certain time limits, but by including Texas Tech in this lawsuit, are they trying to go after university? I don't know. But some of those statements are interesting. They don't belong in the petition against Pop Isaacs. But is he
Right.
trying to shadow or trying to forecast what they may be doing if there is a judgment reached against Pop? Now, they can't wait forever because there are statute of limitations, but I would be interested to see what they're going to do with that, because those statements are outrageous against Pop. But is he trying to tip his hand? I don't know.
Here, I'm gonna switch back to the other screen. We have reached the bottom is just the Fortenberry firm, page 9 of 9. So we'll come back here to the main screen. I will, and we'll just talk for just a few more minutes. If you have any questions, if you're watching and you have any questions, you can ask live. Anything you're curious, maybe I didn't cover, he didn't cover. Feel free. We'll give you a few more minutes. Other than that, we'll, Mark's been on here a long time, and I appreciate you doing this, and you were very clear and much better than me. But, hopefully my goal was to kind of clear some things up. There's a lot of misinformation, as I said, going out there, rumors and such, and maybe some of the rumors are true. I don't know, but it doesn't matter. I just wanted to be, clear as to, what the actual allegations are. What does it actually say, which is why I wanted to provide the actual document. It's a public document is, and
And I'll be honest with you, I started becoming more vocal, especially when this hit the news. Let's be honest about it. Texas Tech has a very avid and passionate ex community. Okay, and I follow a ton of people, and I see a bunch of fans and people associated with university, and it's both ways. They're not everybody's pro Pop. Everybody
Yep.
doesn't like what they've read about. The biggest question that asked came out right away was, what in the world is he doing with the 17-year-old? Great question. Okay, but I decided to start being more vocal, just to explain to the process to people, especially those that are like, he should be suspended, he doesn't need to be on the court. Well, hold on, let's and this is what I'm preaching with the TJ Shannon incident, in Pop is everybody back away from the cliff, and there must be some kind of due process that plays out. Okay, based on that presumption, I'm going to take it all the way back to Title IX. Based on that presumption of responsible, allow him the due process of going through the entire process. Let his defense and his interview and his witnesses take hold, just like in the civil trial. And what we said about toward the beginning, there is no vetting in the civil trial. We have no clue what his defense is, what his position is, what Cambridge is going to say, because evidently he's a key player in all this. We don't know any of that. But since we don't know it, whoa, sorry about that. Since we don't know it, let's not go starting suspending people based on that. Let's allow the due process to play out is what my biggest takeaway from all this. And this is what I'm urging everybody to. Before you form an opinion, allow the Title IX process to put it. And I think that was actually one of my tweets, is let the process play out because he's presumed innocent. And let's see what comes of the Title IX. Of course, everybody's going to say, I want to see the Title IX report. Sorry, Title IX report is confidential. But allow them to do the investigation. Allow this civil process to play out before we start hanging people or start going after fathers of daughters or even the daughters themselves. Let's just take a breath and let them. Everybody hates this. And I tell people this all the time. You hate lawyers until you need them. And now the lawyers are needed, so let them do their jobs and let the whole process go.
Yeah. Well, we don't have a question. We do have a comment, and it's that Nobu is a restaurant. So I guess it's a restaurant in the Bahamas. That may have been the the photo that was circulating around where you had the Steffi family and then Pop and some basketball players were at the kind of a one-sided bar. You don't see the other side, but you kind of see that maybe. I'm assuming so. I don't know, but anyway, we have clarification, at least according to Stacy G. So I appreciate that.
Thank you, Stacy, because I've read it like 3 times. I'm like, I have no clue what Nobu was. Is it his nickname? I don't know.
Yeah, I like to think I'm hip, but you hear some of these words, from these, tech students and whatever, and I'm like, well, I'm not sure. Let me bust out Google and see what that means.
Yeah, exactly.
And some are fine and some are a little questionable. But you know what, we were all there at some point.
Sure.
Man, I'll if something comes in the last second, I'll pop it up. But man, I appreciate you doing this. Like I said before, we're approaching an hour and a half, so that's I feel like that's pretty thorough. You definitely clear some things up, so I appreciate you, and then humoring me on some of my questions that maybe weren't necessarily pop relevant, but appreciate the follow on Twitter and interacting and. Kind of supporting me when I was kind of talking about, hey, what, I don't think Pop should be suspended. He needs to play until, we know for sure, or at least there's a judgment, I guess. I guess we'll never know, right? It was just them two in the room at the end of the day. But, we'll have a judgment and we can, based upon that. So.
Well, everybody, if you have any questions, at least most of y'all know where to find me on X. Just reach out to me, send me a message. I've already got some messages. I have no problem answering them about especially this area. I don't like to venture out on stuff that I'm not an expert in. That's why we're talking about this civil lawsuit here, and I can opine as to how I would attack it as a cross-examiner. But I'm not going to step out into the civil world and act like I know everything that I'm talking about.
No, I think you did excellent and definitely clear some things. And then, of course, he's done, the Gambling Gauchos did a podcast with the Title IX lawyer as well that you can listen to. And then you did, yes, and then you did one with Austin Massey. I think earlier today, or when did you actually record it?
We recorded that yesterday.
Okay.
And for y'all that don't know, Luke Williams, he cut his teeth at the Lubbock District Attorney's Office with me. Him and I were colleagues there. We were actually we go all the way back to law school. Then we were in the Lubbock DA's office together, and then him and some other guys that we served at the Lubbock DA's office started a law firm in Dallas. But Luke and I talk at least once a month. We're still keep up with each other, especially a lot of Title IX. We kind of pass back and forth
Yeah,
depending
yeah.
on a schedule, depending on where in the state it is. He sends me stuff that's south of a certain, like south of Waco, if he can't get down there, and if there's something up in Denton or UTA, I'll say, hey, call this guy Luke. He knows what he's doing. He's the expert. So, but yeah, very informative.
There you go. Well, hey, give my man. Where's my finger? It's always hard. I got to, check out. I've got, it was the Marc Chavez Law. I think is that your at on. I still say Twitter. I don't care, but X. Anyway, it's in the description. His email's in the description. So hit him up if you need to, or message him on Twitter. Or just tag him. I'm curious too. I want to see what's going on. It's definitely interesting. You definitely hope that it works out for all involved. It's a terrible situation. I don't mean to make light of it. If you felt I did, I was trying not to. It's very serious, and we take it serious. I do think Tech in the past has been very serious on these allegations. We've had players suspended in the past, so I think they're trustworthy. I know fans, or especially other fan bases, were like, oh, they need him to play because he scored. He said 4 games with 20+ points, but he's just, which is pretty amazing with what he's going through. I know he's having a hard time. This is not easy.
I made a comment on X that given everything he's going through with the allegations and his father's sick.
Yes.
He is doing a hell of a job staying focused. And I'm going to reiterate. I'm going to be very honest with you that I'm not sitting here telling you I'm pro pop. I'm a girl dad, so I understand kind of the father's perspective of protecting his daughter. I get that. But I'm also, you brought me on. I'm telling people how I look at it from a litigation standpoint,
Right.
and where there are some deficiencies in the lawsuit, frankly, or where they need to shore up certain things if they really want to solidify them. You forget my background's a prosecutor. We are trained to mold a case to perfection beyond a reasonable doubt. That was our standard in the criminal world.
Yeah.
And a civil trial is a lot less standard. But if you take that background about molding a perfect case beyond a reasonable doubt, that can carry you over into a plaintiff's world in the civil side.
Yes, and there's at the very least there are some holes that need to be filled in. We kind of covered that. So, but yeah, definitely definitely pray for Pop's dad. He's going through it. He was in Lubbock, maybe still is. I know he's been able to go the past couple of games, and he was here at the game on Tuesday. And we got a big game on Saturday, so
Yes, sir.
we'll see what happens. But
For those of us that can't get down to Lubbock or up to Lubbock, you guys get there, be loud, cheer. I got my McCaslin coat just to, I'm just impressed with what he's done in the short period of time as far as the culture change and getting everybody to buy in. Okay, that's number one. You can see this team has bought in. All right, and that's going to carry this program hopefully with McCaslin for a long time, much beyond this year, because everybody's starting to talk about, oh, we're a tournament team. Look at it big picture. This guy has the ability to reach people just like we have in Joey McGuire. The ability to reach people and change the culture. So that's what I'm loving about it. That's why I'm celebrating with my red jacket on.
Oh, I like it. That is a very much a McCaslin jacket.
It is.
I agree with you. Well, I think that's all I have. So we will. It's a little bit after 9, so I'll let you go. I know you. we both have work tomorrow, so we'll do that and get it bright and early and read them on. And just full disclosure, we were supposed to do this last night, but I had to cancel because I was at the game on Tuesday and I was loud and my voice. It's still a little raspy, but it's a much better than it was yesterday. So thank you for working with me and allow me to delay it a day as well. But I definitely appreciate you. And y'all go follow my man. I've got his Twitter like I said, and you can contact him for any of your legal needs. Other than that, guns up, let's go, and
Wreck 'em.
that's right.
All right.
All right, I
Have a good
appreciate
evening.
you.